Alright, and I'm continuing my commentary on Craig Murray's recounting of this past week, these 4 days of the Julian Assange extradition hearing. But the videos for the first 2 days were put on limited monetization by YouTube, even though it's just commentary on current events. So apparently only the news media gets to talk about this while making money. If you go against the narrative, you get punished. And as I've covered, most of what the news media is telling you about this is wrong. So if you appreciate what I'm doing, then please support me, especially if you didn't watch an ad. It's easy to do on BitTube, BitChute, or Library. There's a tip button right there on your screen, so you can just use that. Otherwise, just go to donate.bogosity.tv and you can donate with PayPal or crypto. So we'll go into day 3 of the hearing. Please watch the first 2 videos to see what happened the first 2 days and what a circus this thing has become, and a lot of the kind of preambles to what's about to happen right here. Because as Murray said, the prosecution adopted arguments so stark and apparently unreasonable, I have been fretting on how to write them up in a way that does not seem like caricature or unfair exaggeration on my part. What has been happening in this court has long moved beyond caricature. And most of it is about the magistrate, Vanessa Barister. And as we've seen in the first 2 days of the hearing, she is determined to get Julian Assange no matter what, even to the point of the prosecutor being baffled by the things she's saying and doing. And Murray says, Vanessa Barister is under a clear instruction to mimic concern by asking, near the end of every session just before we break away, if Julian is feeling well and whether he would like a break. She then routinely ignores his response. Yesterday, he replied at some length he could not hear properly in his glass box and could not communicate with his lawyers. At some point yesterday, they had started preventing him passing notes to his counsel. In other words, they are absolutely denying him the right to participate in his own defense. Barister insisted he might only be heard through his counsel, which, given he was prevented from instructing them, was a bit rich. This being pointed out, we had a 10-minute adjournment while Julian and his counsel were allowed to talk down in the cells, presumably where they could be more conveniently bugged yet again. Edward Fitzgerald made a formal application for Julian to be allowed to sit beside his lawyers in court. You know, like serial killers do. That's what they let people do. I mean, if they're really violent, they might, handcuff them to the chair or whatever, but according to Fitzgerald, Julian was a gentle, intellectual man and not a terrorist. Remember, the only things he's being accused of is chatting with someone over the internet and posting things to a website. Barister replied that releasing Assange from the dock into the body of the court would mean he was released from custody. To achieve that would require an application for bail. How did she manage to say that with a straight face? I'd like to know. And again, even the prosecution intervened on the side of the defense to try to make Julian's treatment less extreme. He was not, he suggested diffidently, quite sure it was correct that it required bail for Julian to be in the body of the court, or that being in the body of the court, accompanied by security officers, meant that a prisoner was no longer in custody. Prisoners, even the most dangerous of terrorists, gave evidence from the witness box in the body of the court next to the lawyers and magistrate. In the High Court, prisoners frequently sat with their lawyers in extradition hearings. In extreme cases of violent criminals, handcuffed to a security officer. Barister replied that Assange might pose a danger to the public. Gotta love their little weasel words that they throw out. Oh, she's just concerned about the safety of the court members. And I love this next part from Murray. Barister started to throw out jargon like a Dalek when it spins out of control. Risk assessment! And health and safety featured a lot. She started to resemble something worse than a Dalek, a particularly stupid local government officer of a very low grade. No jurisdiction up to Group 4! Recovering slightly, she stated firmly that delivery to custody can only mean delivery to the dock of the court, nowhere else in the room. If the defense wanted him in the courtroom where he could hear proceedings better, they could only apply for bail and his release from custody in general. She then peered at both barristers in the hope this would have sat them down, but both were still on their feet. In his diffident manner, which I confess is growing on me, Lewis said, "The prosecution is neutral on this request, but of course, I really don't think that's right." He looked at her like a kindly uncle whose favorite niece has just started drinking tequila from the bottle at a family party. Yeah, I mean, this is what I want to know. Why is that glass room even there? Because we don't have those in American courts, even when, like mass shooters or whatever are being tried. I mean, Assange has been denied the basic right to sit next to his attorneys and give them information and instructions without being overheard. He was made to sit at the rear of the court behind thick glass where he couldn't even hear properly. Every request for Assange to be able to sit with his lawyers was denied by the judge. UK listeners, please tell me, is this how it works in the UK? Do they routinely lock the defendant in a glass box at the back where he cannot consult with his legal counsel and say that to let him sit next to his lawyers would mean a release from custody and require bail? Is that normal? If so, there is no justice in the UK. So the proceedings began with barrister saying that a photo had been taken inside the courtroom and that it is a criminal offense to take or attempt to take photographs inside the courtroom. Yeah, what do you think this is, a public forum or something? And Murray goes on about how she herself doesn't seem to have a photo on the internet or even much of a bio, trying to find out any information about her at all. Just doesn't seem to be there. And also his amusement at the idea of attempting to take photos being a criminal offense. I mean, how do you attempt to take a photo and then fail? So, anyway, I'm going to skip all that. You can read it yourself. It's pretty entertaining. But getting back to the legal points, the prosecution is arguing that the extradition treaty has no force in law. The UK and US governments say that the court enforces domestic law, not international law, and therefore the treaty has no standing. The prosecution argue that the Extradition Act of 2003, under which the court is operating, makes no exception for political offenses. But then the defense counsel, Edward Fitzgerald, argued that the Extradition Act of 2003 alone is not enough to make an actual extradition. The extradition requires two things in place: the General Extradition Act and the extradition treaty with the country or countries concerned. No treaty, no extradition was an unbreakable rule. The treaty was the very basis of the request, so to say that the extradition was not governed by the terms of the very treaty under which it was made was to create a legal absurdity and thus an abusive process. Yeah, I mean, the treaty is the whole reason why they're there. They're saying, hey, we've got a treaty that says you have to extradite this guy, extradite him. And they're saying that the treaty is irrelevant to that proceeding. Oh, my God. Fitzgerald pointed out that while the Extradition Act of 2003 did not contain a bar on extraditions for political offenses, it did not state there could not be such a bar in extradition treaties. And the Extradition Treaty of 2007 was ratified after the 2003 Extradition Act. So Barrister tries to make the claim that since they didn't have it in 2003, that it doesn't matter that they actually put it in the treaty in 2007. So Fitzgerald points out, international jurisprudence had accepted for a century or more that you did not extradite political offenders. No political extradition was in the European Convention on Extradition, the Model UN Extradition Treaty, and the Interpol Convention on Extradition. It was in every single one of the United States' extradition treaties with other countries, and had been for over a century, at the insistence of the United States. For both the UK and US governments to say it did not apply was astonishing and would set a terrible precedent that would endanger dissidents and potential political prisoners from Cuba, Russia, and regimes all over the world who had escaped to third countries. So Fitzgerald went on to point out that there were two types of political offense. A pure political offense is like treason, espionage, sedition. A relative political offense is when a normally criminal act is committed with a political motive. So all of Assange's charges are espionage charges except for the computer misuse charge, which is a normally criminal act in order to breach the Official Secrets Act. And the accusation that Assange was trying to harm the political and military interests of the United States was in the very definition of a political offense. Well, then Lewis starts up with this really crazy idea. A treaty is not binding in English law because it's not passed by Parliament. Treaties are made by executives, which cannot make law, and therefore there was no abuse of process here, and therefore no rights were invoked under the European Convention. Lewis said that the U.S. government disputes that Assange's offenses are political. In the UK, Australia, US, there was a different definition of political offense to the rest of the world. We viewed the pure political offenses of treason, espionage, and sedition as not political offenses. Yeah, sure. Right, yeah, let's just rewrite the dictionary. Only relative political offenses, ordinary crimes committed with a political motive, were viewed as political offenses in our tradition. In this tradition, the definition of political was also limited to supporting a contending political party in a state. Lewis will continue with this argument tomorrow. Well, that ought to be entertaining. Is it just me, or has the prosecution's case seriously morphed from the time it started? In order to try to make this case against Assange match the law, he went from hacking and releasing classified information, definitely a political offense under his own description since both of those are ordinary crimes, to merely espionage, which somehow isn't. But I guess we'll have to wait till day 4 to see if we can figure out if he can end up pulling out any kind of consistency here at all. So until then, stay strong and be free.